It's another interesting time to join us on the program Law and You, where we take our time to look at, throw light in some gray areas as regards the law and how the law applies to such concepts or phenomenon. We've been discussing the issues about succession in estate planning, and gradually we get into the climax of this as we look at the element of trust in succession in estate planning. And my name is Philip Omo Gyupong. I have the custodian of the law with me, Akigbe Oseogo, a legal practitioner. Thanks for coming.
Thank you for having me.
Now, let's look at what trust means in estate planning.
Okay. For you to have a trust, you must have three elements in place. The person, of course, who creates the trust in law is called a settlor. So there must be an object. So he's creating that trust for a purpose. There must be a purpose. There must be an object. There must be an asset. There must be a beneficiary, right? And it must be clear that his intention is to create a trust. So, for example, a man has a house and he says he wants the trustee now to manage that house for the benefit of a certain person. So the beneficiary is identified, the property is identified, and the purpose is identified. So he says, I have this property, I want you to use the proceeds of rent coming from that property to ensure that the beneficiary is educated up to a certain level. Once that arrangement exists, we say a trust is created.
Okay.
Now, as between the settlor, the owner of the property, and the trustee, there is a document that regulates their relationship called a trust deed. So everything the settlor wants the trustee to do is defined in that document.
Okay.
Right? So once that happens, once there's a trust deed, there's a beneficiary, there's an object, the purpose is known, the asset is identifiable, then a trust is created. But I must also hasten to say that for you to say a trust has been created, there must be that deliberate attempt by the owner of the property to transfer the property to the trustee. So when he transfers the property to the trustee, in the eyes of the law, that property is no longer his. That property now belongs to the trustee. And so the trustee can now carry out his responsibilities as outlined in the trust deed for the benefit of named beneficiaries.
Okay. Let's look at how different is this from a will, for instance, and also try to look at what advantage it has over a will. Okay,
so we've said that a will starts to speak when the testatrix or the testator dies. But for a trust, the trust can become operational even in the lifetime of the
settlor.
What are the benefits of a trust? So a will, for example, once a will is written and lodged at the probate registry and it's read and all that, it becomes a public document.
That's for the will.
For the will. Anybody can apply to get a copy of the will. A trust is private.
Okay.
It's as between the settlor and the trustee. So as regards privacy, you don't have that with wills. But with a trust, it's a private arrangement. A trust can be effective in the lifetime of the trustee, and then, of course, a will only speaks upon the demise of the testator or the testatrix.
Okay.
So, but once the property is transferred by the settlor to the trustee, that property no longer constitutes part of his estate. So the issues of, oh, this property must be given to the first son and the other property should be given to the daughter or whatever doesn't apply.
Okay.
So upon his demise, there will be nothing like, a dwelling house and all of that. No. So once, and depending on, I keep saying that there is no one size fits all. So depending on the peculiarities of the case, if a man wants to ensure that a particular asset is used or used for the benefit of a particular individual, the most effective way of doing that is through a trust.
Okay.
Because his wishes must be, fulfilled by the trustee.
Okay, let's look at what point or what could necessitate one to, have a trust. Because there's this fear, or as reports have it, that for some settlers, seem to be reluctant in transferring their assets to trustees because they fear the relinquishing control. So, at what point should one be nursing having a trust, or what are the category of persons that will be having this, and how do they guide against such a fear of trustee, taking control?
Part of the reason why you are relinquishing that property to the trustee is because you want to save yourself the burden of control. And so you are indirectly you are trying to shift that headache to somebody else to manage. Now, that relationship, remember I said, is regulated by a trust deed, an agreement.
An agreement.
So everything is written under the fine letters of the law, based, under the fine letters of that document. So everybody knows their limits and their how far they can go, right? So who can create a trust? Anyone. Anyone that has an asset. Now, you can have
anyone that has an asset.
Yes, you can have individual, an individual playing the role of a trustee, right? You can have corporate trustees. That's companies that function as trustees. Some of the banks, they have trustee arms, where they assist their customers to manage their assets, to save them the headache of management of those assets. They provide them with advisory services, tell them the do's and don'ts in certain areas, especially specialized assets. So if you have a corporate trustee, for example, you don't have anything to fear. But a trust is like a canvas. It enables you an opportunity to create an estate, carve out an estate plan, however you want it.
Okay.
For example, we have different types of trusts. You could have, it came into my head now, where you want to...
Like the testamentary?
No, you create an asset strictly for charitable trust, for example.
Okay, charitable trust.
You create an asset, you have an asset, you want the proceeds from that asset to go to charity. You create a trust because the trust will outlive the settlor. So even when he's no more there, the trustee has a duty to continue. Now, the trustee has a duty in the eyes of the law to ensure that he carries out the terms of the trust. And where he fails, he could face some legal, there are some legal consequences that will follow.
Okay.
So the property can never be that of the trustee. It's not his property. He is only managing the asset for the benefit of the beneficiary in line with the terms of the contract. Okay,
but you said anyone that has an asset, can embark on that arrangement, so having a trust.
Yes.
But what about some who may say, well, there must be a reason why one wants to have a trust, because once you have it, it means you already accepting to relinquish your control over such an asset. Now, could it be for reasons maybe of incapacity?
No. So let me give you let me tie it to an example. So the man has 5 daughters. He already knows that when he passes on, there is a certain brother that will come forward to want to take over some of his assets.
Okay.
Right? Or he knows that, okay, he has maybe, let me give another scenario. He has 4 daughters and a son. He knows that once that son comes in, he's going to squander the whole thing. And he has faith in his daughters.
Okay.
Now, why would he wait for that son to come forward upon his demise to take over the assets and squander it based on his fears?
Okay.
He would rather create a trust.
And watch it grow while he's in his lifetime.
Because the moment he creates a trust, those assets or that asset he's guarding against no longer constitutes part of his estate. It now goes to the trustee. And once it goes to the trustee can now manage that asset based on his instruction.
When you say manage, you mean as in take over the operations of the asset?
Of course.
Okay, what about if it's a company, for instance, that needs some required skills, you know, some technicalities or very, very intelligent part of such a venture, which even the settlor has and knows that if he's not handling it, there may be some dangers, you know, inherent in the fact that he's not involved in the operations. So what could make such a settlor, you know, give out or relinquish such control when he knows fully well that probably in such issues about expertise, you know, such trustees may not be able to, you know, render up? Are there not issues like that that could also call for a revoke of the agreement, or is it not revocable?
No. So once that happens, if it's a specialized business, all the trustee needs to do is to get someone who is an expert in that business to run it. But whatever, like, and I must emphasize, the relationship as between the settlor and the trustee is regulated by a contract.
Okay.
So let's say the man has a company that specializes in producing some pharmaceutical drugs or whatever. And he needs someone who is specialized in that field to run the business so that the business doesn't go aground upon his demise.
Yes.
The trustee then has a duty to get the required expertise to ensure that the business continues to run.
Can the settlor recommend?
He can recommend, but the important thing is that the business must continue to run.
Okay.
And the business must generate the income or whatever. Or
okay. So under this arrangement, it means that the settlor is not really out of operations. It means the settlor can also bring in his input, you know, about how he wants the business to go, or how the trustees should go about it.
Well, it depends on the trustee. But
it can be spelled out in that form.
But to make in an ideal situation, he relinquishes his interest in that property.
Because that's what it's all about.
Yes. Transfers to the trustee and allows him to carry out his wishes based on the trust deed. Now, let me digress a bit. Another way of creating an estate plan is owning assets through companies. Owning assets through companies. The old case of Foss and Habertu, the company is different and distinct from the owner of the company.
Okay.
So the company has a life of its own. So if I buy assets in the name of my company, those assets are not mine. They belong to my company. I'll say
those assets are not yours,
so
but they belong to your company.
Yes, property purchased in the name of a company does not belong to that individual, but the company.
Okay.
The only person that can do anything about that asset is the company, not the individual. As long as
you're talking about a board, for instance, if there's a board of trustees,
the company is the owner of the asset.
Okay.
So John Nigeria Limited buys a house.
Okay.
That house does not belong to John.
No.
It belongs to John Nigeria Limited. The only person that can sell it
is John Nigeria Limited.
Now, what makes up that company is the shareholding.
No. The only person that can sell it,
John Nigeria Limited.
John Nigeria Limited,
yes.
Not John.
Not John.
Okay.
Yes. So if a man purchases a house and then upon his in the name of a company, and then upon his demise, his eldest surviving son walks into the company and says, give me my father's property.
Okay,
the
I get it.
company will say, you are
It's not
joking.
possible.
The property never belongs to your father.
Okay.
The
belongs to the
property belongs to the company.
I
And
get
it is only the company that can do as it pleases. So if you look
So
at
that's the security.
a form of security. So if you look at these concepts, you see that it's an indirect way of creating an estate plan. You know, one of the ways of regulating what goes on in a company is shareholding. So the man who has majority of shares can dictate what happens in the company. So if I want to create an estate plan, for example, I would establish a company. I will own 70% of the shares of that company and distribute the other shareholding. Now, it means that I'm in control. I can now decide to say that my interest in the company should go to X, Y, Z. If you notice, I have tacitly created an estate plan. So, and that's what a trust does too. A trust assists you to determine who will take a benefit out of an asset, either in the lifetime of the owner of the property, settlor, or even when he's no more.
Oh, okay. When you're having that trust, an individual, for instance, having that trust, like the settlor, what guarantee is he holding on or hope that the trustee will not run the business aground? Or what's the insurance?
The trust, there are duties of a trustee. So for a professional, for a corporate trustee, for example, the trustee has a duty to render accounts.
Okay.
So
to the settlor?
Yes, to the settlor and to the beneficiaries.
To the beneficiaries.
Yes.
So okay. Yeah. At this time, the beneficiaries are already aware.
Of course.
Okay, so they are even part of it.
They are part of it. The trustee.
Or like in the will.
The trustee is accountable to the beneficiary.
Firstly.
Well.
Or the settlor.
The settlor and the beneficiaries. Okay. You know, the beneficiaries, they have an interest in the asset, in the whole arrangement.
Yes.
So they have an interest to protect. Now, when the trustee carries out any function that is inimical to the trust, the law will take its course. And of course, nobody, especially the corporate trustees, nobody wants to be subjected to that kind of issue. Okay. With somebody else's asset. And as the name implies, trust. The guy has given you that property to manage because he trusts you. And so the trustee has a duty to ensure that he does not breach that trust. Okay. That's why we get the phrase breach of trust. You know, he trusts you and he expects you to ensure that you take utmost care in managing the assets. So it's not just anybody that can be a trustee. Someone who has integrity.
Okay.
Someone who can be trusted, can play the role of a trustee.
Well, so much you've just said on the importance and significance of having a trust. Well, in case you're just watching, it's Law and You, and we're looking at succession in estate planning. And what we're looking at basically is trust. And I've been speaking with a legal practitioner in the person of Barrister Akigbe Oseowo. Now, let's look at this aspect of, in the overall, when someone dies intestate or without even writing a will or trust, and not traceable to any relatives, and there are assets, but you couldn't trace the relatives or children of an individual of the deceased. What happens to the property?
The government takes over.
Oh.
There is a department in the, the administration of the public trustee and administration of estates law, AG and PT. So someone owns property, he dies, no will, not traceable to anybody. The government takes over through that department. Okay. The public trustee law, where you have the AG and PT, is a department that should ordinarily take over the assets and continue to manage the assets.
Okay.
There are certain responsibilities they have over that asset.
Okay.
In fact, the AG and PT ought to render accounts to the governor, such that the fact that the person is dead doesn't mean that the property should run aground, right? So the government has that duty to, take over the assets.
Oh, okay. When you say the government has a duty to take over the asset, or does it mean as in to hold on the asset pending on when maybe there could be relatives? Or
Yes. So the government takes
otherwise,
over.
if any relative shows up,
Or things like that, yes.
the relative takes it,
Yes.
even without a will or a trust.
Without
or
a will or trust. In fact, once the government takes over, once the AG and PT takes over, he applies to the High Court for letters of administration. That is the authority to manage the assets, right? So, so to say no asset just goes like that. So it's either there's someone to manage, there's a relative, or the government takes over through the Office of the Administrator General and Public Trustee.
Okay, that's why it's very important to have an estate planning
Yes.
in this direction.
Exactly.
so that's the importance of it. Now,
Exactly.
let's look at in the overall. Let's look at what do you see as setbacks, because this issue of trust, I know will, we could have it commonly practiced or done in Nigeria, but the issue of trust, is it a common practice in Nigeria?
Well, formally and informally. So if the man tells his brother that, please, I'm giving you this property, but I trust you. I'm asking you to manage it for my female daughters, or for this particular I don't want to sound like a chauvinist. I'm giving you this property to manage it for this particular person because of certain, factors. You've created a trust and then you give it to him.
Okay, informally.
Informally. Now, formally, the trusts are actually for the category of persons we call HNIs, high net worth individuals. I'll tell you a kind of trust. It's interesting. Offshore trusts.
Oh.
So
Okay, we have types of trust?
different types of trusts. You have charitable trusts.
Okay, you said
You
it.
have offshore trusts. You have a blind trust.
Wow.
You have so the trust concept is broad and interesting. I'll tell you about an offshore trust. So the man has assets in Nigeria.
All right.
And managing those assets in Nigeria, the tax implication is mind-boggling. So what does he do? He sets up a trust, appoints a trustee, not in Nigeria, but in another jurisdiction, in another country, where the tax implication is minimal. So that trustee is managing from there. He is not subject to the tax implications that affect him in Nigeria.
Awesome.
So it saves the man of those costs. But it's so flexible that when the trustee from the tax haven, such a country is called a tax haven.
Okay.
Now, when the trustee from the tax haven is repatriating the funds, is repatriating it back to the beneficiary.
Okay, that's when it to be taxed.
No, so it saves the estate of any form of taxation.
Okay.
So you see, the asset is here, but the trustee is there.
Okay.
And the trustee is only regulated by the tax laws over there.
Okay.
Which is
I
beneficial.
think we're going to throw more light on this in the part 2 of this topic. It's quite awesome to have you on set with me. Thank you very much for your articulation in that. Well, this is what we'll call it a wrap on this segment. Don't forget to join us same time next week. Goodbye.